All right. Fabulous. We got a few people who are coming on in. So we'll go ahead and get started. I'm sure we'll have some more people that will start to trickle in momentarily. But what we'll do is we'll start off and tell you a little bit about our speaker today. Our speaker today is Veronica McClendon. She is an estate planning attorney and real estate attorney who specializes in helping individuals and families manage, preserve, and transfer assets that were inherited or acquired during their lifetime. She provides legal services in a personal and inviting manner. Through her company, McClendon Law and Consulting, she offers service to include drafting wills, estate plans, consulting with families on clear and title to their heir property, an LLC, and other business entity formation. When she's not helping the family recover, retain, and acquire land, she enjoys building community locally. Veronica has been on during her time at Duke Law School. She enjoys spending time homeschooling her daughters, gardening with her husband, and building relationships with other community builders. So, of course, in this session, we're going to talk about some of the basic elements that everyone should know when it comes to estate planning. And so one of the big things, too, I wanted to be sure to share why this was important to me. And so I know we've had a few posts that really just talked about, do you have an estate plan? And then some people are saying, well, I don't have any assets, or maybe I don't have a husband or children or what have you. But regardless of that, there are definitely a number of reasons of why you should still have an estate plan in place. And so one of the big things when we talk about why you should actually have an estate plan in place, something personally happened to my family earlier this year. So January 7th of this year, my sister had a stroke while she was at work, actually. And she was found in the restroom of her job. And so my sister was then rushed. She actually lives in Atlanta. She was rushed, of course, to the hospital. And that very night, when my parents called me, I was in the airport actually flying back home from a work trip. And so they're updating me to try and figure out what's going on, how serious it is. And my sister, who is 39 years old, had to have a couple of brain surgeries that final night. And they actually had to take a piece of her skull off and do actual brain surgery that very night. And my sister was in ICU for a whole month. And for 2 more months, she was in a rehab facility. And she has yet to recover fully to the point where she has her mobility or coherent speech. And so what that meant and what I saw during that point in time, I spent a lot of time flying back and forth from where I live in DC to Atlanta literally every weekend. And so during that time, my family had to kind of try and figure out a number of things in terms of what bills was she paying? Do we have access to her accounts? How do we continue to pay for things? Because we had zero idea in terms of how long this would last. And so unfortunately, my sister didn't have these items in place. And we were doing a number of kind of patchwork things in order to make sure that things were taken care of, despite the fact that she wasn't in a position to take care of these things on her own. And so it really made me think of, well, what if something happened to me? I not only manage a lot of my own things, but I definitely manage a lot of things on behalf of other family members and so forth also. So if something happened, would my family be in a situation that they felt like they could easily pick up and continue to pay bills on my behalf or make medical decisions on my behalf? Who would that party be? Would it default to somebody that I didn't want to make those decisions? Would it be easy for that party? So if it's in my case, it would be my mother. Would she be in a situation where she could easily pick up those documents and kind of figure out where those were? And so it became a important thing for me to put those things in place, because oftentimes I would always say, I don't have any children, I'm not married. If, whatever happens when I die, whatever happens to the assets, it's not that big of a deal. But it became a bigger deal once you see that to be incapacitated and unable to actually make those decisions, that is actually pretty common. And as Black women, unfortunately, we suffer from strokes at a much higher rate than a lot of other people as well, which means this is something that I'm sure other families have had to deal with. But it struck a nerve with our family. And even my mom, who I've talked to a number of times about, do you have a estate plan in place? Are you prepared? Who do you want to take care of things? Even she made sure that she had her documents in place. And then she also made sure that she passed me those documents also. And so we'll talk a little bit about kind of that process once you figure out who that party will be. But it became a much bigger deal, regardless if you own a lot of stuff, regardless if you have dependents and so forth, that estate plan is not simply for the day that you die. It can actually be a document that is helping you during the time that you're living as well. So I want to thank Veronica so much for being here. It's key, it's imperative. It's one of those things that unfortunately I think we overlook. It's not the sexiest of titles or topics to go over. Not a lot of people want to talk about that day. And unfortunately, by the time you want to talk about it, it might be over, or you don't have a chance to actually plan for it adequately as well. And so I definitely want to jump right on into it and say, just Veronica, tell us a little bit about some of those basic documents that everyone should have, and about what those documents are.
Okay. And thank you so much, Rosalind, for sharing your personal story, because I feel like you really could have did this presentation just from your personal experience. It's often when people have gone through it that they really are able to communicate it better sometimes than I can, just how important it is to have a good, solid estate plan in place. So I am going to talk about some key documents that everybody needs. There's, this is going to be the 101 class. There's a different level, there's other things that we could talk about if you're at a more advanced level, but I want to make sure that everybody is at a baseline level with regard to estate planning. Particularly since we are in the midst of a pandemic. Like this is even if you don't have an example like Rosalind shared with us, we are in the midst of a pandemic, and we see every day just how people are being caught off guard with this, because nobody was planning to be in this situation. And it's exposing us, it's exposing our weaknesses and our vulnerabilities. And so it's important for everybody to be mindful of these things. So what I'm going to go through is what I'm calling the get ready, be ready checklist. Because people say that, you want to stay ready so you don't have to get ready. But when it comes to estate planning, just like Rosalind mentioned, you don't always have a chance to get ready. Sometimes, well, most of the times when it comes to estate planning, you already need to be ready. So for everybody, I don't care if you're married, if you have children, if you own a home, if you don't, everybody's going to need an advance directive for healthcare. And what this and I do want to put the caveat in there that I'm in Georgia, and each state has its own names for these documents. But basically in Georgia, what it is a power of attorney, healthcare power of attorney, and a living will combined. The durable healthcare power of attorney is a document that allows you to choose someone to be your agent, to make healthcare decisions for you. Like Rosalind said, in the example of her sister, it's to someone to say, okay, this is what treatment we're going to authorize, we're not going to authorize. And also, as part of a healthcare directive, you have so I talked about the power of attorney. You also have the living will, which allows you to state what's going to happen if you fall into certain medical conditions, if you're terminally ill, or if you are in a state of unconsciousness and you're not able to communicate with your doctor. What treatment preferences do you have? What would you want your agent or the doctor to communicate about your healthcare wishes? So an advance directive for healthcare, or some similar document, whatever it might be called in your state, is something that everybody needs if you're over the age of 18, because you need to have somebody in place who can make healthcare decisions for you. And you also want to make sure that some of your wishes are respected. And the only way to do that is to have it written down in a legally binding document. So that's the first thing that everybody needs. And the second thing that everybody over the age of 18 needs is a financial power of attorney. You need, just like, Rosalind, she really could have done this presentation for me, because everybody needs a financial power of attorney. If you become ill, or you're not able to talk to your doctor for whatever reason, or not your doctor, I'm sorry, if you're not able to handle your finances for whatever reason, you need a financial power of attorney in place to have a person who's going to be responsible, have the proper legal authority to handle your money, to access your bank accounts, to pay your bills. For example, if you ask your mom or your neighbor to call your utility company and they don't have the proper authority, the utility company's not going to talk to them about the bills that you may owe. So you need to have somebody who has that authority to communicate with your utility companies, your bank, your bank representatives, or whatever accounts need to be accessed. If you have Social Security, you need a power of attorney in place to make sure that someone can communicate with those agencies or those entities on your behalf. So those are two things. I don't care what you own, what you don't own. These are things to make sure that somebody can take care of you and that they can take care of your finances. The third document that everybody needs to consider at least is a will. There's very few people, I would say a small subsection of people, who do not need a will. And I would say that would be if you just do not own anything. You don't own a car, you don't own a house, you don't have any bank accounts and things like that, then you might not need a will. But under most circumstances, you're going to need a will if you own anything. And a will is a written document that it goes into effect after you pass away. So this is one that this is the other two documents. The first two I mentioned, those are documents that are in effect when you're living. But the will is something that goes into effect after you pass away. And it's basically just a way for you to say who's going to get what of what you own. But it also allows you to name someone who's going to be responsible for settling your affairs. So that's another thing. Even if you don't really own a lot, you still might want to put somebody responsible in charge of your affairs to make sure everything's distributed the way that you want it to be done. Should I keep going, Rosalind, or do you have any questions?
Yeah, let's keep
that
going.
I should
You have questions along
okay.
the way, make sure that you drop those in the chat. I'm watching the other within the actual event as well. So if you're watching on the event, let me know there. I'll be checking if we have any questions there also.
Okay, awesome. So with the will, like I mentioned, it allows you to say where your property goes after you pass away, but it also allows you to name an executor who's going to be responsible for handling your estate after you pass away. They're the one who's going to make decisions about who gets what in the event that your will is not very clear about those decisions. And then another thing that a will allows you to do, if you have children who are under the age of 18, it allows you to say who would be the guardian of those children. Or if you leave money to any children under age 18, a will allows you to name a trustee who will handle any money for children, because children can't inherit large sums of money or property. So they would need to have a trustee in place who could manage those things that you leave to them. So those are like the basic documents that you definitely need to have in place. You want to consider, depending on the level of assets that you own, you might consider having a trust or some other things in place. But a will is definitely a good foundational document to have as part of your estate plan. And then the last thing on that checklist that I want to mention now is life insurance. And I'm not a life insurance salesperson, so I don't know about all the different types and how, I'm not going to be the one to recommend which type you need. But I will say that it's a good way for you to be able to leave a legacy, to have life insurance, because, you don't know when your time might come. But if you have life insurance, it doesn't take time to build up that wealth and those assets. The life insurance policy is effective as soon as you purchase it. And so then if anything happens to you, you're able to leave something to the people you care about. So that's another thing that you want to consider as part of your checklist. And I know it's probably sounding kind of grim right now, and sometimes it starts out that way, but we can make it fun. I have lots of stories to tell. You know, if y'all ask me some questions, then I can pull some stories out to try to make it a little bit less grim. But you kind of got to lay the foundation so that everybody knows, you know, what's what's what. So.
And we do have a couple questions. One, how long does it take to draft and report these documents? So if someone's just getting started, how long should it take them to get everything in place?
Well, you know, that's going to depend on you, and it depends on the attorney. Um, when I work with clients, I give them a list of things that they need to collect before we have our first consultation. And sometimes it takes a while for the client to get those documents together. And so in that event, that depends on the client. But then after that, it depends on the attorney. Just based on their caseload, it shouldn't take long to fill out the documents, but it's just a matter of if the attorney has a lot on their caseload or not. That would dictate how much time it would take. If y'all excuse me one moment, got a little one who came down the stairs. Yes. Mommy, I don't like the Little Mermaid. Well, watch something else then, okay? Look, go on up. Go on up. Just find something. Jessica told me that was gonna happen. I should have just because there's no reason to bother me. But anyhow, so yes, it really just depends on what is going on with the client and what's going on with the attorney as far as how long it's gonna take to put those documents together.
Now, you mentioned that you said you would have your clients pull together some information. So one of the questions, what type of document should you bring when meeting with the attorney?
Okay, so if you own anything like real estate, you want to have your deeds, anything to do with your real estate. If you have bank accounts, it's a good idea to go ahead and have a list of all your bank accounts, have a good sense of what's in them, just so you kind of have an idea of what the value of your estate is. And then also, you want to make sure that you know what type of for example, you want to like with your bank accounts, you need to know if it's if it has a payable on death designation, or if it's a joint account where if you passed away, then the money that's in the account, would it automatically go to somebody else, or do you have someone designated in that account to receive anything that you have after you pass away? So it's good to have that information for your attorney. You also want to have, and the questionnaire that the attorney gives you usually is going to ask for all this information. It's going to have you to list the people you want to leave your property to, their ages, making sure that they're over the age of 18, and then just a little bit of information about them, like where they live and what their relationship is to you. So beneficiaries, assets, the assets are the things that you own. And then if there's any special circumstances about any things about your beneficiaries that your attorney needs to know. For example, if you have a family member or a loved one who is an adult with a disability and they receive needs-based assistance from the government, public benefits, you want to make sure that you let your attorney know that information so that they can draft your documents properly. And also, if you have a child who you love them, but you know that they're just not good with money, you want to make sure that your attorney knows about that person so that they can draft the documents appropriately. So that's just like a general idea. If you have retirement accounts, life insurance policies, sometimes it's good to have that information as well, so that the attorney can make sure that there is a beneficiary clearly designated and that there's not going to be any issues about who those benefits are going to go to.
And then Darlene has her hand up. So I'm going to, Darlene?
Hello, can you hear me?
Yes, we can hear you.
Okay. I'll say that was by mistake, but it was. But I will ask this question. For someone who already has the documents in place, would you recommend that they have a second opinion, someone else to look at the documents that's already been drafted by another attorney?
I would say that depends on if you have some reason to believe that there might be something wrong. If you have an attorney who is an estate planning attorney, I would say that is important. Um, a lot of attorneys do wills because it's a good way to make a good income, like a good bread and butter income. So a lot of attorneys do wills. But they're not estate planning attorneys, and so sometimes they may not look at all the things that they need to look at when they're drafting those wills or the estate plans. So I would say if you have an estate planning attorney who did your documents, I wouldn't spend the extra money to have someone else look at it unless there was something that made me think there was possibly something wrong in how it was drafted. You do want to review your estate plan at least once a year. And so some people might want to, as part of that, have another attorney review their estate plan. But I believe if you have an attorney who's licensed in the state of Georgia, who prepared your documents and you don't have any reason to believe something was wrong, I would recommend just, trusting that attorney's professional judgment. And then if what comes to what later down the line, hopefully they have good insurance and they have, to cover any issues that might have happened. I will say that you should read your documents carefully because sometimes attorneys will draft a document based on their experience or based on what they thought the client said. So you want to make sure that you look at it yourself. And if there's anything that makes you say, that doesn't quite sound the way that I want it to sound, it seems a little different than what I want it to happen, go ahead and talk with your attorney about it. And so another thing on that, I would say, make sure that you go over your estate plan with your attorney. Don't just let them give it to you and you sign it and let that be it. You want to make sure you understand every paragraph. I would. And I try to explain it to my clients, even if I don't go in depth about a particular paragraph, I try to at least cover each paragraph so that they can say, oh, what is that? Oh, I don't really know what that means. So just at least go over it with the attorney that you have to make sure that you understand it correctly and make sure that everything is written in the way that you want it to be written.
And that's a good one too. When I was going through my process, one of the things that was kind of in the standard document, it talked about, this was in the financial power of attorney, is that party would have access to originate loans. And I'm like, well, I wouldn't want them to originate a loan. And it was, so there are things that, I mean, if you're incapacitated for a month, 2 months, what have you, and then you fully recover, and now all of a sudden you have more debt than when you started because this person has the ability to, those things are going to be in your actual document. And so once again, when I was saying it's not just about when you die, but anything could potentially happen that puts you in a situation where someone else has to step in for a short period of time, maybe for a longer period of time. And so just to kind of understand what that means, and how to prepare for that. So those are like those parts within the document. I mean, they're probably going to send you these pages and pages of documents that you may not feel like reading, but just to kind of understand the individual pieces. And I'm like, well, why would I want them to get a loan on my behalf or liquidate assets or whatever it may be? Because who knows if it's going to be 1 month or 10 months or 10 years, but just in terms of what you would want them to do in order to provide your care. I have another question. It says, my child is 20. I plan to leave almost everything to him. In the event I get married, can my spouse contest the will?
That's a very good question because yes, your spouse can contest the will under that situation. Sorry, baby was coughing. I'm sorry, y'all. I have a 1-year-old and a 6-year-old. So, but anyhow, yes, your spouse can contest the will because the law assumes that if you were married, that you would want your spouse to get something from your estate. And so if you create a will that you want to leave something to someone before you get married and you don't want your spouse to get anything from it, I would say first you need to put explicitly in your will that this will is made in contemplation of future marriage. And essentially, this is the way that I want my estate to be distributed because this is how, even if I get married, I'm anticipating this as I'm drafting this will. So you want to make sure that's in there. And that's not a part of the standard form. So if you have an attorney do it for you, make sure that they put, this is in contemplation of marriage. Another thing that you want to do is so another way that the spouse might be able to contest your will. If that provision is in there, then they don't really have the well, my spouse wouldn't have made this will without including me. They don't have that argument as much because the will says it's made in contemplation of future marriage. But they could also file for what's called a year support. At least here in Georgia and in many southern states, they have year support. I think other states don't have it. Like, for example, New York, I can't remember if they have explicitly a year support, but they have provisions in place for the spouse. But here in the South, in Georgia particularly, it's called a year support. And it's basically saying if you were married, and they were assuming that it's the wife that survived, but that this law survives our patriarchy rules. But it says that if you're married, that you're entitled to receive a year's worth of financial support from your spouse's estate. And so that could be in the form of money, but it also could be real estate. That's a way that spouses get houses in a lot of cases. They'll file for a year's support. So, one thing you want to, I'm thinking as I talk about this, how can you plan around a year's support? You might, I would recommend, this is what I recommend anyway. You would want to revisit your will if you get married. I'll just say that point blank. Because you got to be able to, you never know. You might want your spouse to get something after you find out how much you love them and how much you want to, you might want to leave things to him or her. You might want to leave your things to your spouse. So you want to revisit it when you get married. And you might want to, depending on who your spouse is, put specific provisions in place to say, I left life insurance for my spouse. So I'm providing for them through life insurance. So basically here in Georgia, I say, because it could be different other places, especially in some more progressive states. In Georgia, the law is going to assume that if you're married, you want your spouse to get something from you. And so it's really hard to overcome that unless you put particular things in your will, and it still could be an issue. So I would say talk to your attorney when you get married to kind of see what your particular circumstances are at that time and what things you can do to get around it. Like I said, one thing is to say I'm doing this will in anticipation of future marriage. And another way would be to say that I'm providing for my spouse in other ways outside of this will. But there still could be issues with that. So definitely talk to an attorney in the case of a subsequent marriage, a marriage in the future.
And then also I'll piggyback on that too, because depending on the state that you're in, your spouse is automatically your beneficiary unless they sign a document saying, I know that I'm entitled to this, but I'm going to say that I don't want to. So that's a lot of times the case in your retirement documents, and it's state specific. So if you forge his name, or if you just decide, I don't care, I'm just not going to put his name. And usually they're going to ask you, because a lot of those systems are going to be online. They're going to say, are you married? Have you assigned it to your spouse? And then if not, do you have this document on file? Just to be sure that by default, in a lot of states, it's going to be your spouse. And if you don't want it to be your spouse, you'll have to have a document signed by your spouse saying that they acknowledge that this is not going to them. So one thing, just to be certain of there. We have
Could I say one more thing on that? I just want to say that's a really good point, and that's a possible way to deal with it. Like she said, it's state specific. So each state is going to be different as to whether or not that's going to hold up. But I think that is a good way to kind of cover your bases, to have your spouse agree. But of course, they might not want to agree. So that's another issue. But one thing with what she said about your state, your spouse being your beneficiary automatically. In some states, that is the case. In other states, it's going to be your spouse and your children. Like in Georgia, if you have a spouse, you have children, they're all entitled to receive from your estate. And so I can go into the trouble that can come from that, or we can go to the next question, whichever one you want to do. It might come up later.
We'll definitely circle back because we got a couple more questions in here.
Okay.
So we have one. It says, what price range should you reasonably expect to spend on estate planning? And I guess it's definitely going to depend on, are you a billionaire or 100,000?
Right. That is true. It's going to depend on the value of your estate, and the different factors that you have to consider. If you are in your second marriage or third marriage and you have children from multiple marriages, that's going to be a factor. If you have a beneficiary with special needs, that's going to be a factor. So it's going to be based on the size of your estate. It's going to be based on the number of contingencies that you're dealing with. But then it's also going to be dependent on your community. So I'm in Macon, Georgia. The cost for an estate planning attorney in Macon, Georgia is a lot lower than an attorney in Atlanta. And then if you go to New York, that is going to be a whole lot more. So it's really hard to give a range. I would say here in Georgia, if you want a basic estate plan, it could range from $300 to $1,500. I would say that would be your range for a basic estate plan. I know it's a huge range, but it's going to depend on, one, is your attorney an estate planning attorney? Because that's going to make a difference. If it's an attorney who does wills, they're probably not going to charge as much as an estate planning attorney. And I would say, don't go cheap. If you are a single person, or if you're married and you don't have any children, you can maybe get by with going with someone who doesn't have a lot of estate planning experience. But I've seen wills by attorneys who are not really thinking about all the issues that come with estate planning. And I'm not saying they're legally wrong. It's just that they don't always account for the different contingencies that could come up. So I always caution people, make sure you don't just go to an attorney who has you just fill out a form and then they'll send your documents back and that's it. You want to go with someone who's going to talk with you about your situation to make sure there's nothing that the form may have missed. So with that being said, I'm sorry I can't give a really great range, but I guess, like I said, maybe from $300 to $1,500 here in Georgia. I've seen that range of estate planning services.
And I'll piggyback too to say, some of those contingencies are some of the main things that are going to be the issues of contention that can come up. If I know a lot of the ladies mentioned they don't have any dependents, they're not married. And I remember my estate plan attorney, my mother is the person that's listed as executor and so forth. And she said, but don't you expect her to die before you? And I'm like, that's the way it's supposed to be. It might not happen. Mm-hmm. And so sometimes your default is my mom. Well, then if things go the way that they're supposed to, as children, we're supposed to bury our parents are not supposed to bury us. So if things go the way they're supposed to, in reality, I got to come up with a contingency. So what happened? Mm-hmm. And she forced me to kind of think through that and say, okay, well, then what happens? And so I think a lot of times, you think about that first person, but in reality, if that first person you think of is your parent, you would hope that you're going to outlive that parent, which means now you're stuck with no one to take over in terms of your estate as well. So just something to kind of be aware of also.
Mm-hmm. And I'd say with that, you want to always have a backup executor. So you have your first person, but then you have your secondary person. And then also remember that your estate plan is not for life. I always tell people, if you are just getting started in your career, you're just getting started with building wealth, if you're doing what you're supposed to be doing, you will need a new estate plan in a few years because your assets are going to change, your life circumstances are going to change. So I would say what you mentioned, what your attorney mentioned, is definitely a good point to consider. But then at the same time, as a younger adult, if you have your parents as your executor, then you just, as you get older, you probably will update your estate plan anyway. So, and then it's also, I always tell people, if you have an estate plan and if anybody who's mentioned in your estate plan passes away or some reason their circumstances have changed, and so such that you would want to change your plan, then you can change it at that time. So I tell people it's good, like your attorney advised, it's good to think ahead to say, okay, I would expect that my mother wouldn't be the one who's administering my estate. But if something happened to me within the next 5 years, perhaps she could be. And we don't want that to happen, but estate plan is all about just being ready. It's the thing that I tell people it's an essential investment, but sometimes you hope it's a waste of your money because you hope that you don't need it for any time soon. But like life insurance, you might buy a 10-year term life insurance. You hope you don't need it in that 10 years, but it's there if you do. And we just don't want to be caught off guard.
Exactly. Yeah. So we have another question. It says, we live in Texas, but most of the people who would be listed as a guardian or beneficiary live in Georgia. Does that impact how or where we should create these documents?
That is a good question. The law that's going to control your estate is the law of the state that you live in when you pass away. So I would say that what matters most is where you're living, as far as what laws, what attorney you consult with. Consult with an attorney in your state, because your state is going to control how your estate plan is administered. There might be some issues that would come up in another state, but I would think it's beyond the control of your estate plan. For example, if you said it, you named your family members in Georgia as a guardian, then your state's estate plan is going to, your state's law is going to control how your estate plan is administered. But then once the children are moved to custody of someone in Georgia, that's when Georgia law would apply. But your estate plan is more than likely not going to get into those issues. Your estate plan would have handled things from beforehand, more than likely. But that's a good question. I'm just trying to think of it, if there are any situations that I can imagine where it would matter with state. But in most cases, they're going to look at where the person who passed away, where was their residence at the time of their death. And that's the law that's usually going to control.
So we have another question. It says, being that DC is not a state, hopefully one day, could I go to Macon, Georgia to have my will drafted?
Y'all are just asking some really good questions. So DC, I think that federal law would control DC estates. Any other attorneys on there? Any DC attorneys? Because
well, I'm in DC, and I did have my estate plan documents drafted by an attorney in DC as well. And she did talk about kind of that difference, because I'm in a similar situation as the person in Texas and Georgia. My parents are in Georgia, and I live in DC. Just about all the property that I own and so forth is titled in DC as well. So it would be DC law that would take precedence in order to pass my estate along. So definitely, I mean, we'd love to find some other estate attorneys and kind of put together a list in some areas and so forth to pass along their information. So Joy, we'll work on that to get you some names also.
Right. I didn't know if anybody was on here to answer that question, but I would, DC. So when they talk about choice of law, they don't say your state, they say your jurisdiction. So I would say that DC would be your jurisdiction, which is what law would apply over your estate if you're a DC resident. But y'all asking some good questions that I had to like expand my thoughts. Like, okay, we're looking at this nationwide.
And I think that's the big thing too, especially for people who, I mean, a lot of people in DC are transplants from somewhere else, but people are more and more mobile in terms of kind of where they're going to live or where the rest of their family is. And so that might be, and that's one thing I wanted to ask. So what are some of those triggers of when you should review your estate plan? You talked about if you got married, if you had children. So what are some of the other triggers that might say it's time for me to review my estate plan?
Yes, definitely under those circumstances. Married, if you get married, you get divorced, you have children. And if anybody passes away that you mentioned in your estate plan, if you name somebody as your executor or your agent and your power of attorney or your healthcare directive, if there's someone who's listed as a beneficiary, which is the person who will receive the assets that you leave behind, if something happens, if they pass away or they become ill or you just don't like them anymore, which can happen, you want to update your estate plan under those circumstances. Um, you also want to update your estate plan. Well, I would say not necessarily update it, but just review it at least once a year because you just never know what could happen. When I have a lot of families that I work with who own family land, who own heirs property, and I tell them to look at the way that the local laws are because you own land and you might have something in mind for your estate plan based on how things are when you did your will, but then Walmart, well, I won't say Walmart, like a shopping center could locate right next door to your family land. So that's going to change the way that you envision. It might have been more of a farming type property before, but then now it has the commercial potential. So you might want to adapt your estate plan for those circumstances. Trying to think if there's anything else that might warrant a review. Um, even if someone didn't pass away, if they're becoming older or they might not have the same capacity to handle things that they did before. That they got too many kids and you know that they're not going to be giving your estate any attention. It's just not saying too many kids, more kids than they had before. We'll say that because it's can you have too many kids? I don't know, but 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 yeah, so you just want to kind of see if the people who are named in your plan if their circumstances have changed or if your own circumstances have changed. You had a new child, one of your children passed away. You want to make sure that you look at your plan again under those circumstances.
And I know we're a little bit over. Definitely, if you have any more questions, drop those in the chat. One other question that I have is, where should you keep your documents? Mm-hmm. So once you get everything drafted, where should you put it for safekeeping?
So there's a few different options in that regard. Definitely, if you can keep it at home in a safe place, but you want to make sure it's in a fireproof, waterproof safe, somewhere that's locked and is safe from fire and water. And you want to make sure that your executor or whoever you named as your administrator, who's going to be over your estate or trustees, that they know where those documents are located. You also, if you have just a will, if you want to file your will with the probate court, that's an option. They're only going to take a will, so you could file your will for safekeeping at probate court, which is the court here in Georgia, at least in many other states, it's the court where they administer the estates of deceased persons. So you can have your will stored there. It's a natural first place. If someone's looking for a will, they'll look at the probate court to see if it's there. So I recommend a safe at home, or if you want to have it at a safe deposit box at a bank, you just need to make sure that your executor has authority to access that box. Make sure they have authority and that they know what bank is at and all those things. So whatever you do, make sure that you keep it in a place where it's not easily destroyed, not easily stolen, not easily damaged, and make it in a place that your executor can access it. Let's see. There was one more thing I wanted to mention. Make sure it's not in a place where anybody who would get more from you if you didn't have an estate plan, make sure that it's not in a place where they can get it, because if they rip your will up and they get more, you don't want people who have an incentive to tear up your plan to have access to it. Another thing you want to do, so I'm more so, when I'm saying I'm talking about wills and things like that, with your financial power of attorney and your advance directive for healthcare, a copy of those documents are as legally valid here in Georgia. Let me say that because it might not be the case in other places, but here in Georgia and then probably in most places, a copy of those documents are legally valid. So you can keep your original at your safe place at home in your fireproof safe, but give a copy to your agent number 1, agent number 2, and then your sister who's not listed as an agent, but you want somebody else to have those documents. Financial power of attorney and advance directive, you can give a copy and those are legally valid. A will, only the original is preferred in most cases. They can use a copy in others, but the original is going to be preferred, and it's going to take a lot to prove that a copy is valid. So you want to have your original in a place where it can't be destroyed, but it can be accessed by your executor. A copy is good for them to have just so that they know what's in there, but you can't just give copies of your will out for if in case the original's messed up, just use the copy. It takes a little more work to use the copy. So I hope that was clear. That wasn't too much.
And one thing that my attorney told me too is, especially for the financial power of attorney, is to also, and this is kind of, you can jot this down on your own, is to list where your money is. And so It's great if they have access and they can legally, go to your bank account and pay your bills. But if they have to call 20 banks in the area to figure out which that you actually bank with, that might make it more difficult for them. So you want to make the process as easy as possible. Within my plan, it actually talked a little bit about like who takes over your social media. And I was like, I don't know if I want my mom to have that, but it was like some kind of off the cuff things that you can kind of jot down yourself that you keep with your estate plan documents, but they're not the legal draft documents that are included. So that was some good advice because I didn't think about that. Just, all the places that you got a couple 401k plans, and you got a couple things here, here, and here, and here. You got, checking account, savings account here, an online account, those kind of things. Just who do you go to, or how do you make sure that they know where to go with this financial power of attorney?
Right. And this is a good time to go ahead and put those things in a safe place just so that they're there. And there's no searching through boxes and bags to try to get to it.
Any closing remarks?
I just will say, if y'all have any further questions about estate planning, if you want to schedule a consultation with me, we definitely can do that. I will say I would prefer to do consultations with Georgia residents just because I don't want to, if you live in another state, I want you to get your questions answered by somebody who's going to know your state law. But if anybody wants to schedule a consultation with me, you're welcome to call me at 478-227-7503, or you can check out my website. I think Jessica just dropped that in the comments, so you can check that out to see how to book a consultation. But if you have any, quick questions, definitely feel free on the Facebook group to ask any follow-up questions that you have. I'll be happy to answer those and address them in the comments. If it's not too personal, I don't want to be discussing your personal business on Facebook. But just, let's get it done, y'all. Like it's not the most exciting thing to do. It's not the thing that we all want to think about, but I always say set it and forget it until it's time to review it. But, go ahead and get it done, and then you don't have to really worry about it anymore. It's just there.
And we got one more question.
Okay.
When selecting a lawyer, is there there is an option between a friend and a stranger? Should we avoid choosing the friend, or does it matter?
I think first it depends on who your friend is. Because if your friend is going to be honest with you and tell you straight up what you need to do, then, go with them. But, and if you're going to pay them right, I'm just going to be honest. We had a conversation in my estate planning group where somebody was like, I could get this cheaper from the internet. And they were like, okay, well, just get it cheaper from the internet. So if you're going to pay your friend what their price is, then I think that, if you trust that they're going to give you good advice, whether or not they're your friend, I say go with them because you know them. You know their integrity, you know their skill set. Hopefully you have some idea of that. But really, it's a matter of who your friend is and who the attorney is, whether you go with them, I would say. And then if you want to know your business, attorneys, we're supposed to keep things in confidence, but, you don't know if you want them side-eyeing you every time they talking to you.
Perfect. All great questions. Thank you again, ladies, for joining us. We have another great speaker lined up for next Monday. That is already in the events tab. If you have suggestions or have speakers, or if you have some other estate planning attorneys that we can provide as a reference for some of the people in some of the other states, definitely let us know that. And so thank you so much, Veronica, for joining us. And everybody have a good night.
Yes. Bye.